Rarieda lawmaker Otiende Amolo and his Suba North counterpart Millie Odhiambo were part of the legal team and say it was a daunting task to convince the principals to file a petition.
My role, together with my colleagues, was to give advice. Our clients had the option of accepting that advice or rejecting it. I do remember in our final meeting, they posed the question very directly, and I ventured to answer it on behalf of it. And they asked us, if we were to go to court and you have assessed the evidence, what is our chances of success? Many advocates usually answer that question 50-50, which is a way of evading any responsibility. I told the principals at the evidence, having studied the way the court has dealt with some election petitions, especially of governors, since 2013, considering the approach and the time we have, I would put our chances of success at 60-40 in our favor.
But once the decision was made that to go to the High Court, then preparatory and very quiet preparatory work commenced, and a lot of evidence was collected, and it was collected away from, any public place.
In 2013, Raila Odinga, who was then CORD's presidential candidate, filed a petition to challenge Jubilee's Uhuru Kenyatta, thrown out on a technicality. So what conviction informed the 2017 decision?
Well, the difficulty, of course, when you are dealing with a legal issue is not just the issue, especially when it's political in nature. It's not just whether you had grounds. From the legal perspective, we were very sure we had very solid grounds, but this was a very highly political matter, and not only was the whole country focusing, but it was the whole world that was focusing on Kenya. Because we had been so disappointed in the past, many people were like, even though we have very good grounds, we are not too sure whether our Supreme Court is mature enough.
Because of the general institutional arrangements we had in the new constitution, and because Raila Amolo Odinga stated that he did not agree with the decision, but he respected it, it stopped us from going the way we had gone in 2008. In 2017, what was different was, first of all, we had anticipated the possibility that the IEBC could botch the election. And therefore, the process of collecting and collating evidence started much earlier than it did in 2013. Number two, the approach in 2013 focused a lot on the traditional interpretation of presidential election petitions, and that is what we call Section 83 of the Elections Act, whether there were irregularities and whether they affected the results. But in 2017, we focused on that and on its interpretation and persuaded the court to overturn the position the Supreme Court held in 2013 and many years before that. The third thing that was different was that in 2013, the team started by focusing more on the legal principles. The legal principles are often convoluted and sometimes you lose people. And therefore, in 2017, we decided to turn it on its back. And we started by focusing on the facts. And that is why we came straight to the regression analysis, just relating the numbers in terms of how they worked out. And then you saw that it is only much later that then we came to the principles, which were presented by my colleagues, Advocate Paul Mwangi, my other colleagues, Awele, my other colleague, Professor Sihanya, and the others.
Why they took some time before filing, I think, is because they wanted to be sure that everything is in place so that the scenario of 2013 does not repeat itself, that you are filing documents late, affidavits late. This time they filed everything on time.
There was a lot of information, and especially the killer punch was this, I don't know whether you call it a logarithm or whatever it is called. And when we got the expert to share, even I was blown off. I was like, wow, you know, because I think, in fact, for the first time in my life, I said, now I understand why I ever did maths in my life. Because you feed in an equation, and it actually gave you a semblance of how the interference actually happened.
NASA insiders say evidence gathering, collating and compilation was a major headache on sifting and picking the compelling evidence within a very short time.
It was evidence that was collected by statisticians and other professionals who did not focus, who did not have a keen mind in terms of what does the court require, in terms of what would it take to persuade the court. So I think the most challenging part that I can, and I was in charge of collating the evidence and presenting it in a way that a court of law can appreciate. The most challenging part was to try and analyze the hundreds, in fact it was hundreds of thousands of documentation, reduce it into a way that flows, a way that can be presented in court. And that is what we eventually came up with, the over 67 volumes, which came to, well, over 40,000 pages. Jeff.
We could see the kind of machinery that has been put in place for the case. So we knew nothing will be left to chance this time. And we didn't want to hear that there are things that have been filed out of time. So everything and anything from Mandera to Migori, from Kitale through Busia to Lamu, all that evidence was gathered.
Because everybody was very tense. So when they ran back, when they ran and all these things were here and everybody was screaming and people didn't know how we are moving them and beating the jam. So I just said, you know what, guys, we are getting motorbikes. So I called motorbikes, and when I called the motorbikes, they came 10. The jockeys, they were all wearing Jubilee. It was so funny. They all had Jubilee reflector jackets. So, of course, they were Jubilee guys. But we said, how are we going to take these things with Jubilee guys? And we said, are they not going to disappear with the files? They were all in cartons. So we said, no, what we're going to do is you will sit 2-2 per motorbike. You put the files, and then somebody sits on the motorbike, and then we discovered it was not possible. Only one person could sit with the files which were in cartons. So we said then another person will follow so that this Jubilee guys don't disappear with our files. So it was so funny. And then at some point now I said for the guys who were around me, the ones who were around me were in Luo, so I was short waving. So I said, how many people here who are Jomaj? And who have Jomaj? Jomaj basically means in Kijaluo security guys. But when you say it in Kijaluo, it also has a sexual connotation. Then all the men carried their hands and say, we are here.
Other than meticulous and intricate evidence gathering, NASA is said to have also changed its litigation strategy to play the underdog card.
We knew, and we had studied our colleagues from the other side, and most of them had adopted a very bellicose and boisterous way of doing the matter, the same way they had done it in 2013, and we had seen that attitude in 2017. And it's an attitude that was depicted right in terms of their commenting on the merits, if at all, of our case at the time of presenting their case. And we decided what to do. We decided to do what usually you would do. We decided to adopt the exact opposite, absolute humility. And so I think that it may also have worked in our favor, that you are the team that is dismissive of you, is dismissive of the court, tells the court you can't do this, you probably don't understand or know the law. And in advocacy, that sometimes helps, because it helps the court to listen to the other side. It's a natural human instinct to side with the underdog. And in that matter, we were obviously the underdog. And in doing so, I think they took it for granted that the court could actually have the courage to nullify the election. I think they took it for granted that no matter what we say, no matter what they say or don't say, no matter what reasoning the court adopts, it cannot nullify the election, primarily based on the precedent that you say, that it had never happened in Africa, it was only the fourth time anywhere in the world, and the 3 occasions it has ever happened elsewhere in the world, the circumstances were fundamentally different.
We were much stronger on protecting the vote, and that is a very good thing. I mean, it's a very good strategy, especially if you believe you are ahead. That then, you know, in Kenya, because of our history of election rigging, so we said the greater thing for us is then make sure that you protect the vote. And part of then of protecting that vote is to ensure that you record any instances of malpractices. So it was a conscious decision from the beginning. Throughout this process, we were very mindful about observing and collecting this information. You remember the last time we were caught flat-footed?
The casualness of the IEBC, the arrogance of the IEBC, and in many respects the incompetence of the IEBC also helped us. They were arrogant in their presentation. They were rude even in terms of compliance with court orders. And they were completely disrespectful to us as the petitioners, to the court, and to Kenyans who employed them. Because ultimately, every Kenyan wants to know that their vote counts. It is not whether they've lost or won, but did their vote count?
We've got servers here, we've got servers outside the country, we've servers in the cloud, we servers everywhere.
Another top secret by NASA was its operating center that was popularly referred to as the servers in the cloud. Only a few of the leaders and technocrats are said to have had knowledge and access of it.
It was very, very, very difficult. I remember we used to gather, there's a hotel somewhere in Westlands, I can't remember the name, near ABC Place, where we used to go there. So everywhere you go, police were following you. The NIS was all over. It was very, very scary. I remember leaving my house. When you reach Westlands, you have to change to enter another car. You reach ABC Place, you find there are so many policemen. We go to the NASA Capitol Hill, they were trailing us everywhere. We had other places also in Lavington. Where we were going, you go, you gather, you find some people who are suspicious. You don't know who these people are. Because they were determined to try their efforts in case of any information that is being gathered for purposes of maybe presenting in the court of law to be destroyed. But we thank God. And we also salute the many group of lawyers that had volunteered, university students who were coming with the information coming in, doing the analysis, and to present to the lead counsel, James Orengo and Otiende Amolo. Otiende Amolo did very good work.
They had many, places where you may not think that they were operating from. Then they had different groups in different places. And some of the places, I know the team were operating from Baba's home. They were staying there, living there, eating there, sleeping there, and working. Another group was operating from another home. Another group from another, where you may not think about, because it is very, unlikely that you'll think there's a team stationed in Baba's place, the NAP center. So I think it was very difficult to access for even some members of parliament where that team was operating from.
Apart from the over 25,000 pages used in court, there was this, a battery of advocates. It was a 25-member legal team. Lead counsels were Siaya Senator and Senior Counsel James Orengo and Otiende Amolo.
There was no conscious decision to come with a battery of advocates. In fact, there was no time it was sat and agreed that let us have this many advocates. I will have you know that all the advocates who represented NASA in the presidential election petition were volunteers. And to date, none of them has been paid a single cent for representation.
On the next episode is part 2 of the NASA presidential election decoy. We look at the filing of election petition number 1 of 2017, the litigation and the courtroom legal battles, as well as the September 1st Supreme verdict. My name is Duncan Hemba.